Right, good morning, everyone.
Good morning, Your Honor.
We have two cases set for argument this morning. First case is Kevin Michael Brown versus United States. I'm joined this morning by Associate Judge Catherine Easterly and Associate Judge Roy McLeese. And I'm Chief Judge Blackburn Rigsby. Parties ready to proceed? I understand, Mr. Bickoff, you're joining us remotely.
Yes, I am, Your Honor.
All right, are you ready to proceed?
I am. May it please the court. I'm Russell Bykoff, and it's a privilege to be here today and a pleasure. And thank you again for allowing me and other counsel to have the option of doing these arguments remotely. I do see a lot of benefits to doing that. Today's case involves the application of a somewhat problematic statute and then a very important precedent by this court. I call it Gauss or Gauss, authored by you, Chief, Madam Chief, 15 years ago, with an en banc court split 5-4. And it's a case that hovers above my client's case. And we'll be talking about that briefly this morning. Um,
Counsel, if I could jump
yeah,
right in since you raised
yeah.
gauze. In gauze and in many of our other cases in DC as well as in some of the federal circuits, the challenge to the jury panel makeup was made pre-trial. And that seems to be the crux of the dispute, as I understand it, between you and the government here. Your challenge was made was not made pre-trial, was made after the veneer panel was presented to in the courtroom. So can you focus us on why you think your challenge was timely?
Yes, Your Honor. And one other point of dispute in this case, and I'll just note this in passing, is that in quite a few other cases, both mostly federal cases, maybe in DC as well, the government has conceded error and suggested that the court remand the case to the trial court to allow the defendant to exercise, as this defendant was not, Mr. Brown was not permitted to do, his quote, virtually unqualified right to inspect jury records and lists. Uh, as this court said in Gauze. So the government has argued that this was an untimely request, but it wasn't. The I think it's called the veneer, people call it the panel. 54 people came into the courtroom at the start of trial uh, to be subject to the process for jury selection, in which ultimately 12 jurors were selected and two alternates. Of the 54 people, three people in this city with a very diverse city population, but only three of them were African American. My
Right.
client was is African American.
But at that point, there was not a request made for any of the jury selection process records that you, I think correctly stated, you have a right to. You and
Yes.
another appellant have a right to, but you didn't, or they weren't requested. I don't
Well,
know.
Your Honor, I beg to differ. If I may, let's look at the record. Mr. Burrell is presented with this veneer, 54 people, three African Americans. Ultimately, there was one African American
Right,
on the
he makes a
panel.
challenge.
He makes a challenge.
He does make a challenge, but at that point, he doesn't say, and I'd like the opportunity to get discovery and to, under the DC Jury Selection Act.
Yes, Your Honor. So if we look at pages 3 to 10 of my brief, where I quote extensively from the record, and we look at the December 5th trial transcript, I call it TR2, pages 74 and 76, Mr. Burrell says that he wants access in connection with an effort to he wants to review them overnight and make my argument for tomorrow.
Right, he makes that after the 14 jurors are already seated, but not initially when the veneer panel comes into the courtroom. Um,
That's
and,
right.
and
That's right. That's right. So remember what the judge said, Your Honor. On that same transcript, TR2 from the 5th of December, the judge, Judge Park, tells counsel as soon as he says he makes a remark when he's presented with this unbalanced and apparently unfair veneer. He says, I have an objection. And the judge says, do it after jury selection. At that point, the judge has clearly superseded the statutory requirement because it, quote, ordered otherwise. Normally, you do it before uh, questioning of the first juror begins. I think it's before any individual juror is examined, unless the court orders otherwise. In my
I take your
experience,
point, counsel. I take your point. Let's
yeah,
let's assume that because of the trial court's statement that the discussion of this could be continued after individual questioning of jurors,
yes,
that we should treat this as though a discovery request was made at the time of the initial objection. Treat it as though that's the case.
thank
There's
you.
still a question, I guess, of whether that is timely. And let me again, a discovery request made then would have been timely. And let me step back and just ask more discreet, more abstractly. So imagine that a case is getting ready to go to trial, and the jury, the large jury panel arrives, and the judge, as here, starts getting into some of the process of jury selection, but hasn't yet individually questioned a juror. And imagine that a defense counsel says, by the way, before you start questioning individual jurors, I would like discovery of jury records to support a possible jury service and selection act. And the trial judge says, that's kind of disruptive and late. Maybe I may have a standing order about when motions are supposed to be made, and there's a rule about when certain kinds of motions should be made, and we're in the middle of jury selection now. We haven't had questioning of individual jurors, but that's pretty disruptive. And assume again that the defense attorney doesn't say, "Oh, and I have an excuse for this, for this delay." Do you think the trial court has discretion to deny a discovery request at that point, either by saying that's just unreasonably late, or maybe by saying, "Well, really, in substance, that's a continuance request because we're in the middle of things, and you want to go off and do other things rather than have this trial go forward as scheduled, and I'm going to treat it as an unreasonable continuance request." Does the trial court have discretion in that area? Do you think?
Well, that's what happened here. Exactly. Mr. Burrell,
But
when he
I'm
said,
just asking, except I'm asking in general, do you
oh,
think that the
sure,
trial court has discretion to say, this is a discovery request? The statute doesn't say anything about timing of discovery. It says when the motion has to be raised.
yes.
And I'm trying to figure out whether your answer to the abstract idea is, yes, a trial court has discretion in deciding whether to grant a discovery request at that time, or to view it as a continuance request and to grant it or deny it.
I think the trial judge has the discretion. The trial judge also has the responsibility not to abuse its discretion. The trial judge also has the responsibility to recognize that there's a case out there, gauze,
That's
that
all fair, but
governs.
just in the hypothetical I gave you, if a trial court said, uh, the defense attorney doesn't give an excuse for being late and just says, "I've got this idea. I realize that we're just about to get to the point at which my motion would be required to be filed, and I would like discovery." And the trial court said, "I'm not inclined to grant that request. It's unreasonably untimely." Would that be an abuse of discretion in that hypothetical case?
It could be. Now, let me add to the hypothetical. There are no black or African Americans on the panel. The trial counsel sees this only when everybody files into the room. His client is bouncing up and down in the chair, going crazy, and says, I'm from Ward 7 and 8. I don't see anybody who looks like me. I think I'm getting an unfair
Right, but
cross section.
counsel, a
Yes,
fair cross-section challenge is really about the process for selecting the jury. It's not about the result, right? You could have a fair process that still produces some anomalous results on occasion.
correct.
You could have a fair process and then still walk into court one day and have a veneer that has all white women between the age of 50 and 60.
Right,
And that doesn't necessarily mean that the process is broken.
right.
So I guess I'm not quite understanding. Are you saying, do you, to follow up on Judge McLeese's question, do you think that the trial judge could have a standing scheduling order that says, you know, look here, you have to have all your motions to suppress in by X date. And if you want to raise a fair cross-section challenge to the jury, that has to be filed a month before, and you want discovery, you have to make that discovery request a month before trial.
Well, it would be a little bit odd because this problematic statute does say you can make your motion in writing and with sworn affidavit up until the questioning of the first juror. So the statute itself contemplates you can do it on the day of trial. Now, does it give you much time? No, that's one of the problems.
Counsel,
As,
the difficulty I'm having with what you just said is the statute does contemplate that you can do it at the time of trial, but the it is file a written motion supported by affidavits. It doesn't, by its terms, contemplate that you could make a discovery request on the day of trial. Or are you suggesting otherwise?
well, there are no time limits for discovery requests. I've come across, and let me just step back from it and say that the federal cases are dealing with a statute that in all relevant respects, the federal statute is identical to this. So the federal cases are very helpful. And I've given this court a list. I sent it in, I think, 2 days ago, of mostly DC Circuit cases and one DC District Court from then Chief Judge Beryl Howell, a very extensive opinion entirely devoted to the jury selection. If
Refresh my recollection, did any of those federal cases deal with a request for discovery on the day of trial?
I think, yes, I think possibly one of the circuit cases, which is the one, either
Counsel, I think
DeFreeze,
it's the
DeFreeze,
28 K letter that you sent and the what you I think accurately described as dicta in the case DeFreeze from the DC Circuit.
DeFreeze from 1997, but as the French say, the more things change, the more they stay the same because the same issue comes back in the DC Circuit's bag show case in 2019. So quite a few years later, DeFreeze recognizes the dilemma that the statute requires a written motion and affidavit before voir dire, even though defendants, and I think this is still the practice in our very own Superior Court across the street, defendants do not see the gender and race of the veneer until they enter the courtroom for jury selection. This prevents defendants from providing a detailed and supported motion outlining their jury concerns at the moment they first see the jury. So the government's timeliness objection might be waived by
Can
an
I just
appellate
ask,
court.
did the government make a timeliness objection in the trial court?
I don't think so. I think the government
I
said
think the government just said they weren't prepared to address the motion.
the government didn't have access to jury data either, so it couldn't
That's what they
explain.
said. So I
Beg
didn't
pardon?
see the government making a timeliness objection to a discovery request.
The government, Your Honor,
Counsel, excuse me.
sorry.
Do you think that the court made a clear ruling on timeliness?
I don't think so. I think the government raised its timeliness objection for the first time in its brief here.
Right, but I'm
The-
asking about the trial judge.
The trial judge put this off until after jury selection. Then he then allowed counsel to quote, make the record and told him several times, you've made your record, it's on the record. And then the judge revisited the issue by telling him that he couldn't possibly meet the substantive standards under Duren and other U.S. Supreme Court precedents for establishing a constitutional or statutory violation of the whole jury process, Your Honor. So he's jumping ahead. He's short circuiting the whole process. Uh, he doesn't. The point I want to make is that the judge could have sent the veneer back to the jury room and said, "Okay, counsel, I'm going to give you this afternoon. I'm going to give you today. Do what many other lawyers have done in these cases. Interview the head of the jury office or staff from the jury office. Call Dr. Seltzer at Howard University. See what he thinks. How these anomalous result like this might have been produced, or whether he's heard of others taking place in recent weeks in the same courthouse. I'll give you another day, counsel. Do what you have to do." And counsel said he actually offered, "I'll write my motion overnight and submit my affidavit." So he's prepared to come back the next day and comply with these strict requirements of the statute for written motion. It's a crazy way to do business, but I understand this is the way the statute does it. Now, let me also add, Your
Can
Honor.
I ask you, I just want to make sure,
Yes.
you said that counsel offered to prepare a written motion by the next day.
Yes.
I didn't, can you show me where that is? I saw there was make my argument tomorrow, but I didn't see anything about like preparing a written motion with affidavits and all that.
Yeah, well, let's see.
I may have missed it.
No, you're absolutely right. I think the words are, quote, "review them overnight and make my argument, review the data overnight, make my argument tomorrow." Uh, I take it by then that I'm assuming he's going to finally look at the statute, and the judge as well, maybe read Gauze and some other cases, and he's going to find out
It does seem a problem that he's not familiar with the statute.
nobody's familiar with the statute, Your Honor. in
Can I
this
ask you another
dialogue.
question? Because
They're all driving flying blind.
Judge Easterly asked you a question, I think, about whether the trial court in its ruling made a clear determination that related to timeliness. And I think you said no. And I just wanted to ask you about some language that seems potentially germane to timeliness. One could certainly debate whether it's clear or not. So this is on page 76 of the transcript, where the trial court is referring, as the trial court previously had, to some efforts that the trial court was aware of, where the Public Defender Service and other defendants had been trying to get information and trying to raise a jury service or jury systems act claim. And the trial court says, there are efforts that are being made by some defendants in other cases in order to get at these issues. And then the trial court says this case has proceeded to trial without those efforts having been undertaken. And which seems like a reference to, we're in the middle of trial and you haven't even started trying to do this. Do you think that is a reference at least to timeliness, or do you think that has nothing to do with timeliness?
Well, I think it has something to do with timeless. They weren't in the middle of trial. They were just starting jury selection.
You're right, middle
the
of jury
judge-
selection, you're quite right.
Yeah, the judge put it off. He heard as soon as defense counsel and his client saw the panel, they knew they had a potential issue. The judge and the government apparently also must have noticed. And you're right. So the judge mentions the cross-section litigation initiated by the Public Defender Service. There's no what I don't understand why Mr. Burrell would have any obligation to join, or his client to join, that litigation, and whether it would even cover his own trial. And then the judge reverts to his statements in violation of Gauze. He's telling the defense attorney, "You've made no prima facie showing of a systematic exclusion." So he's jumping to the end. Mr. Burrell doesn't need a prima facie anything to have access to the jury data. And Gauze goes into quite detail.
No, although whether he had or hadn't is a potentially relevant consideration in the exercise of discretion of a trial judge who's trying to figure out whether a discovery request that seems relatively untimely should nevertheless be granted. So I don't know that I agree that to the extent the trial court was suggesting that was a prerequisite to granting a discovery request, that would have been incorrect. But would you agree that if the trial court is considering what is arguably an untimely discovery request, or certainly a belated discovery request in some respects, that the strength of whatever has already been identified as supporting the claim that discovery might contribute to would be a relevant consideration?
The strength. Yeah, I'm going to have to back off on that, Your Honor. And I'm going to say this: Mr. Burrell did everything absolutely correctly. I don't think he was late at all. I think he jumped out of the to run the race as soon as the starting pistol went off when that jury veneer walked into the room. And he had a Fifth Amendment claim, uh, potentially on equal protection if there was intentional discrimination, Your Honor, Judge Easterly, anywhere in the process. He had a Sixth Amendment claim, which we know from federal jurisprudence tracks the DC JSA claim almost entirely, same standards. So he had two constitutional claims potentially, and he had a statutory claim, and he was entitled to. It's compli I'm not. I don't say it's not complicated, and it's not time consuming. If you look at Smith, the case by Judge Beryl Howell in district court in D.C., the litigation went on long after the defendant was convicted. And one of my former colleagues, when I was doing cases in Superior Court, litigated this for months uh, and put in motion and affidavit after affidavit trying to establish and meeting the substantive requirements to show a violation of the law or the act. She eventually didn't succeed, but
Can I ask you, I'm a little puzzled by, you said on the one hand, it's not complicated, and you suggest that if the trial court had said, fine, I'll give you overnight, that would have been adequate. Even but then now you're describing the course of litigation when one of these challenges was raised involved all sorts of affidavits and efforts to gain information and make arguments. So I'm a little puzzled about the interaction between those two thoughts.
yeah, you can do both, Your Honor, as I've learned from my dive into these cases. Uh, you can continue to have the trial, and you can continue to litigate the jury. It's not easy.
Well, sure you can, but it doesn't seem perhaps the most efficient use of resources, right?
It's
Have
probably not.
members of the public who are giving their time to serve on a jury, and you have the government taking the time to present its case, and defense counsel taking their time to represent their client, and going, and the witnesses appearing and giving their time. You have that whole process, and you're saying in parallel, you can have a fair section challenge that could, long after the fact, upend the result of a trial that otherwise, assume has no other flaws in it.
I think it happens all the time in federal court. Um, Basically across the street or across the park. It does happen. And
Mr.
I'm not
Bickoff,
saying the
how do
challenge
you
is
think, excuse me,
yes.
sorry for interrupting you, Mr. Bickoff. Is it Bickoff or Bykoff?
Bykoff, Long Eye.
Bykoff. How do you think this should work um, under the DC Jury Selection Act?
Well, thank you. That's a great
What should the
opportunity.
process be? How are you reading the statute? So, because conceivably, your client could have raised made a pretrial request for documents and information under the DC Jury Selection Act, and had that material, and thought, I don't necessarily see a reason right now for a motion until the veneer panel walks into the courtroom, and then maybe you take another look at that information. And so some of the federal cases that you submitted to us seem to suggest that maybe the norm is to make these challenges earlier, pre-trial, but sometimes things happen. So I guess what's your interpretation of how this process should proceed?
Well, um, the statute creates the strict timeline before jury selection begins. And it has
Or before the first.
before the first juror is questioned.
Mhm.
So and it is strictly applied in federal court. However, we also have, and that's for the motion. It has to be a written motion. It has to be affidavit. The judge can then decide everything on the affidavits, doesn't have to have a hearing, but the judge may also have a hearing. And then the remedy is no, no jury until there's one that's selected in substantial conformance with the statute, with the act. Um, let's see. Uh, so at the same time, there's this unqualified right to inspect without any timelines. Um, and in this case, Mr. Burrell, as I said before, I think acted as rapidly as he could. Might he have earlier uh, done an investigation, written a motion? He perhaps yes, but it's only when he saw this apparently this anomalous jury, and I like that word, Judge Easterly. But who knows? Maybe an investigation that day or over the ensuing weeks after this trial would have shown there are other anomalies in Superior Court that same day, the same period of time over several weeks. Maybe other.
Counsel, let me ask you a hypothetical just to see. I take it in one way the upshot of your argument to be, assuming that the trial court would have had some discretion to view the discovery request as untimely, that your client has a legitimate excuse for raising it when your client did, because your client, ran up against kind of not maybe a red flag, but at least like a yellow flag of there's something going wrong here. This is anomalous and it merits inquiry. And so imagine a case that was exactly like this, except different in two respects. The first would be that instead of the discrepancy that's at issue here, the discrepancy had been smaller, so that let's say the defense attorney had observed that the large jury panel was, let's say, 20% African American, whereas the population in the city would be 40 to 45%. And imagine that the trial court then responded by saying, clearly ruling on, essentially you're asking me for a continuance to do discovery. This is really late, it's disruptive, and the basis that you have for it is, by no means a prima facie case to establish that there is a jury service act or constitutional problem here. It's by itself not enough to establish a claim. And on balance, I don't think that's enough of a discrepancy to warrant the disruptive effect of granting this discovery request then. Would you say that would be an abuse of discretion, or would you say that that would be a lawful exercise of discretion?
Well, it could be an abuse, Your Honor. There's no bad faith by the defendant's attorney. He's not engaging in dilatory tactics. He's ready for trial, but suddenly this anomalous jury walks in, and maybe it's the tip of an iceberg.
Well, I
Maybe
guess
something.
I just want to get pause for a second there on the word anomalous. I guess, if you're picking lots of juries, it would be anomalous if every jury accurately or precisely reflected the breakdown in the population of various protected classes. So you would expect as not anomalous that in any given jury, there would be deviations of some kind from what would be, an exact proportionate representation of particular protected classes. So I'm a little unsure whether the hypothetical I gave would be viewed as anomalous in any would appropriately be viewed as anomalous as opposed to non-proportional but predictable. Might be a different way of describing that. At least that's what I was aiming for, was kind of non-proportional but predictable discrepancy.
Let me go out on a limb and add to your hypothetical. Let's say that or change your hypothetical. Let's say there were 0 African Americans walking in to Mr. Burrell and Mr. Brown's courtroom for Mr. Brown's trial. None. And let's say that the investigator for Mr. Burrell happened to be available in the courtroom, and Mr. Burrell was able to get word to him, "Hey, look, we have no African Americans in this jury. Look into this." And let's say the investigator, lo and behold, finds some very suspicious evidence that some rogue personnel at the courthouse are engaging in intentional discrimination in violation of the Fifth Amendment. Well, very interesting. None of the statutory cutoff of not being able to make your motion until the first juror is questioned doesn't apply, because this is a constitutional claim now. It's potentially a Fifth Amendment intentional violation. And so I grant that's very unlikely to happen. But even if it doesn't happen and there's no colorable intentional discrimination under the Fifth Amendment, you still got these variances, Judge McLeese, and variations that are statistical. Don't you want to gather some data about numerous juries in the courthouse over a several week period? Go talk to Dr. Seltzer at Howard University, have him run a statistical analysis and see if anything's there. Any place along the
That seems
process,
unlikely, that seems unlikely to be done overnight, that
not going to
whole
be done.
process.
No, it's very, very
Yeah,
difficult to do it
right.
overnight.
Can I ask
And
you
that's why I would
another
say for
question I have?
Joe,
Counsel, just another question I had about what happened in this particular case. I think the remedy that was at least initially requested was to strike the panel and get a new one. Is that an appropriate remedy for a jury service or Jury Systems Act statutory violation? Because it seems if you have an unfair system, striking the jury and asking for a new one spat out in an unpleasant way, but produced by that same defective system isn't a remedy at all. So I was a little puzzled about the remedy that was requested and how it relates to the conceptual underpinnings of the claim that was being raised.
yes, you're right, and that's the parade of horrors that the government raised in its brief. We don't want to have defendants asking for first they get one panel, then they ask for another panel, and maybe they're going to ask for a third panel. How long is it going to go on? And it's going to take all morning or half or the into the afternoon in Superior Court. And I can see the point. There's no guarantee that a second panel would be any better than the first panel. I think the remedy would
Well, I
have
mean,
been
relative to the fair cross-section claim, it will be no better. If there's a
right
violation, it's equally tainted, even if it turns out to not be disproportionate. It's the product of an unlawful system.
of the process. And I admit, Your Honor, these Duren claims under the Supreme Court precedent on the substance of establishing the elements you need, which Judge Park, the trial judge here, went into unnecessarily, in my opinion. They're very difficult to establish, and I know that the jury challenges don't always succeed, but there may be maybe someday people are going to realize maybe some things are missing. Maybe the jury personnel and the rules and the practices and as the court, the DC Circuit said in the more recent case, they said they said the practice is not, it's not a best practice what we're doing. It's not a best practice. Um, this is in, pardon me, Bagcho, I think it is, uh, that the habit of not making the demographic data available to litigants until they see the veneer coming into the courtroom is not the best practice because it makes it, I'm quoting, because it makes it difficult for defendants to exercise their statutory rights to investigate the jury pool while simultaneously participating in the trial. The defendant did not challenge practice in that case, so the issue is not before the DC Circuit. But
Mr. Wyckoff,
yes, ma'am.
I'm going to ask you to reserve the rest of your argument unless there's one final point you'd like to make for a rebuttal, because you did reserve some rebuttal time.
Yes, Your Honor, I will reserve but let me just conclude my thought. Uh, the system is imperfect. It almost certainly can be improved. Parties like Mr. Brown and others need to see that there is an effort being made to draw from a fair cross-section, even if their particular jury is not guaranteed to be reflective of the city's demographic mix. Uh, so we're always trying to do better, and I'm here to say that this case, with the small narrow issue that it presents, is maybe an opportunity for this court to weigh in and say, let's look at the system and let's allow litigants to get their data and see if they can craft some decent challenges that will uh, look at the whole process and find its weaknesses so we can improve it. And I'll reserve the rest, Your Honor. Thank you.
Thank you. Is the government counsel ready to proceed?
May it please the court, Dietrich Hill on behalf of the United States. The trial court did not abuse its discretion in denying the defendant's belated request for discovery.
Was it related? Because under the statute, counsel had until the first individual jurors were questioned to bring a motion. And we've said in Gauze and other cases that they have an unfettered right to some of this data. under the jury's JSA, they raised a challenge before any individual juror had been questioned. And then the trial judge, in his discretion, said, no, let's wait until after the jury is actually seated. So where does the untimeliness come from? There's nothing in the DCJSA or in the federal statute that it derived from that says these challenges have to be raised pre-trial, is there?
Right. I agree that the motion itself was timely under the statute, at least. I think a court could require it to be filed earlier, but the motion was timely under the statute. What wasn't timely was the request for records, because that wasn't made until after the court had denied the motion.
Well, wasn't it short-circuited to some extent? When the trial judge said, you know, we'll hear this challenge and any other arguments that you want to make later.
Well, again, I think it's fair to say that the motion was timely because the judge said, well, I see you've made the motion now in a timely fashion. I'll hear argument on the motion after we've selected a jury.
That's not what the judge said, as the chief just alluded to. The judge said, you can make that argument and any other argument you have after jury selection is included. And, you know, clearly the desire for discovery is part and parcel of the actual ultimate motion that this is not a fair cross section, right? So, and that's how the discussion plays out, that when after the jury has been questioned, they resume discussion of this, counsel again makes his observation about the venire not being representative of the proportion of African Americans in the population. The court says, well, you haven't made a prima facie showing. And then counsel says, well, I can't make a prima facie showing because I don't have the records. I'd like the records. And the trial court sort of says, you know, apropos of nothing, well, there's this other litigation that you're not part of. It's kind of a non-responsive answer by the trial judge, and then denies the motion on the merits again, right?
Right. I do think the trial court first denied the motion on the merits and then counsel made the request for records. But even assuming
Right,
that.
but they're still, I
Right,
mean,
even
they're in
assuming-
the midst of the conversation, right? We're not going to cut this up into little pieces, right?
Right,
Like,
even
okay,
assuming that those.
we're looking at the whole cake. Okay.
Simultaneously, the request for records would still not be timely, or at least at that point, the request for records is within the discretion of the trial court.
Why?
Because-
Why? Because the judge said before, when it's clearly timely, right? Had counsel said before they started examining the jurors, I would like records, and also I'm moving, you know, I'm making a fair cross-section challenge.
Right, but
That would clearly be timely,
the
right?
motion would be timely, but at that point.
No, the
mo-
request for records would be, or you're saying the request for records would be untimely even then?
Because the motion at that point needs to be written and supported by an affidavit. So implicit in that is
Well,
that,
wait, I mean, okay.
is that you have to have gotten discovery in time to be
Did the
filed.
government argue that the motion hadn't been written? I mean, did the government make any of these arguments below?
All the government said below was, we are not prepared to
Right, so the
respond.
government didn't object on the fact that it had to be written or the fact that it was untimely, and it was.
Well, implicit in that, I think it's fair to say, we're being blindsided here. We have no idea. We didn't know this was coming. We're not prepared to respond. And presumably that is because it's being made at the last possible second and there's
But
no.
why is it the last possible second?
Under
That-
the-
I guess like under the statute, can we just take the statute? The
Yes.
statute doesn't speak to when discovery has to be requested, does it?
No,
I mean, obviously, other than it has to be requested before you file the motion, you have to have filed a motion before you start examining putative jurors.
correct.
Okay, so assume that counsel had gone into court and said, we want discovery. We're looking at the venire. It doesn't seem representative of the population. We want discovery. What would be the problem with that?
At that point, counsel isn't just asking for discovery. They're also.
No, in my hypothetical, counsel's just asking for discovery.
Well, but it's going to delay trial. because they're going to need to look at that
Right, but
discovery.
under the statute, why is that untimely?
Well, what this court said in Gauze is you have an absolute right to get the records in terms of whether you have to make a showing on the merits. You don't have to show likelihood of success or anything like that. But the trial court has discretion over timing. And one,
Okay, so there's nothing under the statute that makes that request untimely. You're just saying that the court exercises some discretion because they have discretion about how to run a trial to say that a motion like that is untimely. Is that a fair assessment of the government's argument?
I would say that we'd say that implicit in the statute is that an ordinary discovery request has to be made with sufficient time to be able to file a
Okay,
written.
where do
supporting
I find
motion.
that in the statute?
That's
Sorry,
implicit.
I'm not trying to be difficult, but I'm just trying to understand what the government's argument is.
Because the motion has to be made in writing and supported by an affidavit. I mean, I suppose that if defense counsel thinks I can get all these records the day before and we're gonna work over the next 36 hours with these experts to get together an affidavit and a written motion, that would be timely. But the problem is that once it's going to delay trial, it's within the discretion of the trial court to say, look, at this point, you need to show some justification for why you're requesting this discovery so late that it's going to require a continuance or a delay in trial.
Well, but
something like that.
didn't Mr. Brown's counsel already do that? With the initial motion made when the veneer panel is brought into the courtroom and he says, look, there's 54 jurors here and I only see 2 Black jurors. Mr. Brown is from Ward 8, Ward 7. And I'm otherwise ready for trial. There's nothing in the record, as appellant's counsel said, showing that defense counsel was trying deliberately to delay or to be deleterious or any of the other reasons why a judge might exercise their discretion not to grant some additional time here. And then it goes on, counsel goes on further to say, I just need overnight. That doesn't seem unreasonable to support denying a request that goes to potentially to his Fifth and Sixth Amendment rights about a fair cross-section of the jury here.
And I'm certainly not going to impute a bad motive to the defendant's counsel, but if there's no way for a trial court, ordinary circumstances to distinguish between a request like this, I'm not prepared to make a motion, but I would like discovery right now on the eve of trial and a similar request that was made in bad faith to delay the trial. That's the first thing I would say. So
But the trial judge sees what defense counsel sees. I mean, I guess go back to my hypothetical of, you've got a lawyer who has every faith in the district's jury selection system, but walks into trial, and sees the veneer and sees 54 white women between the age of 50 and 60. Maybe they even all have brown hair, right? And says, wait a second, this looks wrong, and I recognize that, just because, a fair process could result in this group of 54 women, suddenly my antenna is up and, I would like discovery. There's nothing in the statute that says that can't happen. And if the defense counsel goes to the judge and says, I just need 24 hours to look into this, what's the problem with that? Why wouldn't we want counsel to be able to make that inquiry?
I would say, I think defense counsel has conceded that at this point, it's a question of discretion. Under those extreme circumstances.
I know, I'm asking, why would that be an abuse of discretion? If you're agreeing that it's a question of discretion, it's not a question of any sort of statutory limitation, why is that an abuse of discretion in my hypothetical?
To grant discovery at
To
that point?
deny discovery.
Under the more extreme circumstances, the more likely it is going to be to an abuse of discretion to deny it. But I would point out here that the records being requested, for one, it wasn't that extreme.
Why is it the more extreme? I mean, I spike my hypothetical, but if Gauss says you don't have to make any sort of threshold showing, why does Why does it matter?
Because at this point, you're also asking for what functionally will be a delay in the trial.
I mean, trials get delayed by 24 hours all the time. People
That's-
get sick, the judge has to, leave the bench for, a meeting, they question all the jurors, but they're gonna swear them in tomorrow. I mean, that happens.
But in every one of those cases, there's some good reason. And if the defendant
Why
provides
isn't
a
this a
good
good,
reason,
yeah, this isn't a good reason. I'm not hearing really why this is a good reason. I guess I also want to ask, like, do we actually think that the judge made a timing ruling here? Right? I mean, if we assume, let's just assume that the request for records at page 76 of the transcript is, is a potentially timely request subject to the court's discretion. Do we think that the court made a discretionary ruling at that juncture? Because what I see is defense counsel saying, I'd like to get the records, and the court makes this kind of non-responsive answer of, well, there's other litigation going on in the courtroom, so that request is denied.
well, I think
That's what the court says.
yes, I think what the judge is really saying is you're asking for records now that you could have asked for at any time.
But
during-
that's not what the court says.
Well,
The
but-
court, I mean, that might be one interpretation of what the court is saying. But the court seems to be saying, like, look, there's this other litigation that you didn't bother to participate in. And if you wanna really litigate this, you have to be part of this. I guess it's a civil case, right? It's not even a criminal case. I'm not even sure what this other litigation is. And I have no idea why that has anything to do with the timing of this request in Mr. Brown's case, where he has a right to discovery in his case.
Well, what the judge concludes, though, is this case has proceeded to trial without
Well, no,
those
no, no,
efforts having been made.
before the court says that. Right? Mr. Brown's counsel says, we'd like discovery, and the court says, so there is, in fact, cross-section litigation that is happening in this courthouse that is being initiated by the Public Defender Service. Does not appear this defendant has joined in that litigation, so that request is denied, period. Court goes on and later says some other things, but the court denies it then and there on that basis.
Well, I think then the court further explains why it's denying this request when it says, I don't know what to tell you at this juncture, other than there are certain requirements. In other words, you need to make some systematic showing. And there are efforts that some defendants in other cases have made that you need to make.
Well, we
This
don't know
case
what
has
the
proceeded
other
to-
requirements are. The other requirements could be alluding to this prima facie showing that would be incorrect at this juncture.
Right, I'm curious about that, just to piggyback on that question, why the government is interpreting what the trial judge said as other requirements, seemingly referring to procedural requirements about a motion and an affidavit, as opposed to the prima facie showing, which would be inappropriate at this juncture. Because he does kind of go through the elements of Duren and some of the other Supreme Court cases and saying why appellant's counsel hasn't shown enough at this juncture in order to get additional time to make his claim.
Right, but that's on the prior page. On page 75, the court explains, here's why I'm denying the motion. You haven't shown there's some kind of systemic exclusion. Then at the top of page 76, the defense counsel says, well, I can't show that because I don't have these records. I would like those records. And then the court responds by saying, you had an opportunity to get these records. Many defendants have gotten these records. This case has proceeded to trial without you making any effort.
Well,
to
but
get those
doesn't that
records.
presume, I think incorrectly under the statute, that defendant was required to get those records pre-trial? And that's not what the statute requires.
Well,
So the reference to the other litigation, the reference to doing something prior to trial is not, it doesn't have a basis in the statute.
but what the statute does require is that by the time you get to trial, you have to be prepared with a written motion that's supported by an affidavit.
No, it doesn't say that. It says you have to have the motion before the first jurors are individually questioned. So that's why I keep going back to this assumption by the trial judge, and as I read some of the government's arguments in their brief, an assumption by the government that this has to be done pre-trial. Now, maybe it would be better, it would be more convenient, it would be more efficient in some instances, but it's not required. And so is your argument coming down to only the discretion that the trial judge has here, or is there some other basis?
No, I do think it amounts to discretion, but I would point to an excellent example in the Bagcho case from the DC Circuit, where the defendant came in the middle of jury selection and said, I think there's a problem. And I think there's a problem that doesn't relate to records that I could have gotten earlier. It relates to something that the jury office did in my case. And the district court said, okay, hold on. We're gonna stop for a moment. We're gonna get discovery about what happened in your case. And they hear some testimony from a clerk from the juror's office. And then the district court says, well, based on that, I don't think we need more discovery. The defendant says, no, I do think we need more discovery. And the district court says, no, at this point, we've heard enough that I don't think you justified a further delay. And on appeal, the defendant said, well, the district court was improperly saying that I needed to make some kind of substantive showing to get discovery. And the circuit said, no, what the district court was doing was exercising its discretion over whether or not to further delay trial to get discovery. So that was an appropriate exercise of discretion in both directions. First, the district court said, based on the discovery you're requesting now, I do think we need to pause and take a moment to get some discovery.
That just seems like a very factually different case. I mean, where you do allow, where you pause proceedings and you allow for some discovery and you see sort of what comes out. Whereas here, the trial judge just sort of shut everything down and said, you didn't participate in this other litigation, so no.
Right, but the question at the heart of both cases is, has the defendant provided a sufficient justification to?
The sufficient justification then gets back to my concern that I think that the concern that the chief was expressing, that we're now sort of importing some sort of Gauss-like requirement or requirement contrary to Gauss, that you have to justify seeking discovery.
But it's entirely consistent with Gauss to say timing is within the discretion of the court, and when timing is potentially going to delay trial, that may provide a reason for the court to say in its discretion,
Well, Gauss
no, it's
says,
too late.
Gauss certainly says that the courts have considerable flexibility, but it also then says the trial courts must always be careful that it's not undermining the purpose of the statute by requiring proof of substantial failure to comply with the DCJSA, even before litigants have an opportunity to inspect the records that might ultimately support such a finding, right?
Right.
So
Now,
like,
the
that comes
context,
after Gauss's recognition of.
right, I would
considerable
point out the
discovery.
context of Gauss is that they made their motion 6 days before trial. And in fact, the panel opinion in Gauss points out in a footnote that that may well have itself been untimely even 6 days before trial, because you haven't left enough time for discovery and to make this written supported motion by the time before an individual juror is questioned. But the government didn't stand on that argument there, but it points,
And Gauss didn't
no,
decide it.
but it underscores the fact that there is, as you approach trial, there needs to be some kind of justification to delay trial, to functionally get a continuance or a delay.
Was there a scheduling order in this case about when motions needed to be filed, and in particular, any motion related to fair cross-section?
There wasn't a specific to fair cross-section. There was a general pretrial motions had to be filed by November 7th, which is actually almost a month before trial started. Obviously, the defendant missed that by a long shot. The government didn't stand on that argument at trial, but certainly
Nor have you stood on it in this court, nor did the trial court rely on it. Is that right?
No, that's right. That's right.
Can I ask you just to see, I mean, I take it, it seems to be maybe common ground that with the discovery component of this case, it really poses just a discretionary ruling by the trial court about whether to permit it or not permit it in the relevant circumstances. And so I just want to get a sense of how, I know you take the view that in the circumstances here, the trial court was within its discretion to deny what you're viewing as like a delay of the trial or a continuance, a mid-trial continuance, however you want to characterize it. But imagine, I guess, two things. Imagine, different from this case, imagine again that the disparity had been more stark, so that again, let's say there was a complete absence of a protected class where you would expect, 40 to 45% to be represented. And imagine, again, the defense attorney comes in and says, I had no plans to file a Selection Act claim or maybe a constitutional claim, but I'm confronted with something that is at least a yellow flag that leads me to have concerns. And so I realize I'm not in a position to make a motion before, the jury is sitting here, but you haven't started any voir dire of the jury at all, collectively or individually. I realize, if you started with no delay and you aren't willing to let me have some time, then I'm not gonna be able to file a motion as the statute would require. So I'm asking you to delay the trial at least briefly. And I would like to have some discovery, and I would like you to delay the trial a day, and we'll see where we are. I'm gonna go and try to get discovery. I'll see if I can figure out what's going on here. I'll come back and I'll make a representation about what I've learned and whether I think a further continuance is warranted. And imagine the trial court said, sorry, that's just, that's not the way I'm gonna run this system. Would you agree that would be an abuse of discretion, or do you think that that would be within the trial court's discretion?
I'm not going to concede that would necessarily, as a matter of law, be an abuse of discretion. It's certainly, as I said, the more anomalous the panel looks, the more likely it is to be an abuse of discretion.
And relatedly, the briefer the delay that is at least initially requested to present the issue.
Yes, I would say the other thing that's important, though, is what discovery is being requested. Because if it's records that have been available to anybody the whole time, and the defendant's coming in and saying, well, I don't like this veneer, I want a different veneer, then, I think the trial court can fairly.
Well, that's getting a different veneer rather than getting a different veneer down the road after successfully litigating that there are challenges to the system that mean that it should be a different process of generating veneers in the future. I get that's a remedial question that I was discussing a little bit with your opposing counsel, but I guess this part of the reason I asked the hypothetical the way I did was there's a strand in your argument, which is in the nature of you're kind of at your peril, defendant. If you think that if you have any hope of ever establishing that there's a Jury Systems Act problem, you've got to be proactive about that. You can't wait until the day of trial and see a veneer that looks bad. That's just not a legitimate way to litigate. You just have to preventively get the discovery and figure out whether there's a problem in every case. And I guess I wonder whether that is an appropriate way of looking at the statute. It's certainly not the way that the DeFreeze court in the circuit looked at it in dicta. They definitely suggested the idea that at least sometimes it might well be not unreasonable for a defense attorney to have not sort of proactively in every case have a Jury Services Selection Act discovery request. So I have all the information. I figure out whether to make a motion. I may or may not make a motion. And then I may get new data, but at least I've done my discovery in advance.
Right.
Why is that a reasonable way of interpreting the structure of the statute?
I guess I have two responses. First, it's the statute by definition contemplates that it's going to funnel at least the ordinary challenge through certain procedural requirements, because you have to be able to show up. So in the ordinary case, yes, you have to be proactive because you have to have a written motion supported by an affidavit, at least by the middle of jury selection. It's very unlikely that a lawyer is going to be writing that, I guess, by hand in the courtroom while the jurors are filling out their questionnaires. So you have to be proactive. There is room for discretion, and there's an important distinction actually between the federal statute and the DC statute, which is that the federal statute does not inherently say that there's the deadline except as otherwise ordered. So in the federal statute, several courts have said in dicta, well, in extreme circumstances, maybe the court can say you get to file late despite the statute's hard stop.
I don't have it in front of me. The federal statute is different in a couple of ways. It has a different cutoff. I think it isn't about individual questioning of individual jurors. The cutoff is slightly
or in fact 7 days after you should have known. So that
well, the first cutoff is different.
Yes,
it's voir dire as opposed to individual questioning, if I recall. And then there is this kind of belated discovery idea. But the belated discovery idea is that it doesn't help defendants who want to raise such a claim, right? Because it's whichever is earlier.
Right.
So no matter what, that can't help you
Well,
Right.
but doesn't the federal,
after when voir dire starts.
Which is why some federal circuits have said, in.
well, but what about section F of the federal statute, which says that the parties have essentially the option at all reasonable times during the preparation and pendency of their motion to get access to these discovery tools? Doesn't that give you a little more flexibility under the federal statute?
It has not led any circuits, as far as I'm aware of, to say, well, you can get around the hard stop of either the beginning of voir dire or 7 days after you should have known by appealing to section F. Every circuit that I've seen has said, no, that we strictly apply that to prevent dilatory motions and to ensure that these kinds of motions are dealt with in a timely manner.
Can I ask you another question about the abuse of discretion, or whether there was abuse of discretion? Under the DCJSA, the statute says the trial judge has some discretion. Does the trial judge have discretion to push the deadline back to a point in time beyond when the first jurors were questioned, which is what the judge did here?
Yes, I think so.
Why is that? I mean, the statute contemplates that the motion has to be filed before the first jurors are individually voir dired. And here, all the jurors had been voir dired individually, and the panel was seated in the jury box when the judge allowed defense counsel to make an argument.
But I believe it says, unless as otherwise ordered by the court or something to that effect. I don't have it right in front of me. So that is what gives the judge discretion to say, okay, I hear you, you've raised this, but I'm going to hear this, later or tomorrow.
Well, but I guess the point I'm trying to get at is that, doesn't that make the argument that we can't afford even a 24-hour delay to give you these documents less compelling? If the concern, as you're saying, about the judge's ability to exercise discretion over the timing of the trial and the trial moving forward, here the trial judge delays the point in time at which appellant's counsel can make the substantive arguments and request the discovery, essentially, and then says, no, we don't have time to delay anymore, so let's go ahead and go forward. I mean, there seems to be some tension there.
I do think, though, ultimately it comes down to discretion, where the judge is balancing the nature of the anomaly, if there is one, the discovery being requested, and the delay in trial. So all of those come into play. But in this case, the key, I think, was that the discovery being requested had been publicly available the whole time. So there was no reason that the defendant could not have been proactive and at least looked into, is there a potential problem with the way that DC is selecting veneers here?
Can I ask you how far you go with this language about, unless the court orders otherwise? And the tenor of my question is about the comment that you have made that granting the discovery request would have necessitated a delay in the trial, or a mid-trial continuance, however you want to describe it. Could the trial court have, I think suggested by some of the comments that your colleague said, look, we're going to go ahead with the trial, but I hereby say you can go ahead and file your motion. I'm going to give you discovery. I'm going to issue an order saying, if you need an order from me, which you really don't, but you can go off and do your discovery. And if you want an order, and hopefully I'll give you an order saying you can go ahead and do your discovery, but go ahead and do that in parallel. We're going to keep going with jury selection here. We're going to keep going with the trial, and we may end up with a verdict. But I've ordered that you do the discovery you need, and within, 30 days of now, file a motion, which might be a it may well be a post verdict motion, alleging a Jury Systems Act violation if you think you could prove one. Could the trial court lawfully do that? So they proceed in parallel in that way, relying on this language about if the court orders otherwise?
I don't see a statutory bar to that.
And if that's true, then it isn't really, strictly speaking, correct that the request for discovery would have delayed the trial, because the trial court, in theory, could have proceeded on multiple tracks and not slow the trial down.
In this case, though, it's implicit in what defense counsel is asking for, that he wants to file tomorrow morning before anything else happens. And presumably he wants this to be litigated before anything else happens. If defense counsel had suggested, I'm happy to file this motion in a month, then the trial court should have been exercising its discretion to consider that rather than to consider what's implicit in defense counsel's request, which is a delay of further proceedings
I
in this
guess
trial.
just a pinpoint on these facts and then I'll be quiet. You said counsel's asking for a delay till tomorrow morning, but it's already clear. The court has told counsel, I don't swear in the jurors until I give the preliminary instructions, and all of that is going to happen tomorrow morning. So I don't even understand what the delay would have been, like that nothing was going to happen, nothing was going to go forward with the trial until the next day anyway. Doesn't seem like counsel was asking for any delay.
Well, counsel was asking to file a motion at the beginning of the day. And unless what counsel was asking is, I want to file a motion and then the government can respond in 30 days. I don't think that's the way that defense counsel intended the request. And I don't think that's the way that the trial judge understood the request fairly, because the trial judge understood the request, as I read this record, to be, I want to resolve this before you swear in the jury, before you have any instructions, before we hear any testimony, anything else. In other words, understood this to be asking for a delay in any further proceedings in the trial.
All right, anything further, counsel?
Yeah, if there are no further questions, we would ask the court to affirm.
All right, thank you. Mr. Bykoff, we reserved a couple minutes for your rebuttal.
Your Honor, this will be very brief. Appellant Brown is asking for this case to be remanded at this point so that his attorney has the opportunity to do a discovery request or just conduct discovery of jury records. I'm not sure what the government's counsel meant when he said that the discovery was publicly available all along. Certainly some parts of the jury plan ought to be on a website. I haven't noticed that myself, but the cases indicate that some of the material is available publicly on a website, but other parts of discovery in these cases seem to involve interviewing with the jury staff of the courthouse. And then to prepare the affidavits, you often need an expert. So that's basically it. My last point is that the unqualified right to jury discovery under the DC statute is only restricted by the statutory language that says it has to be in connection with preparation of the motion. So once you say I'm going to engage in jury discovery so I can do my motion, that should be the end of the inquiry for any judge. So the judge below committed both legal errors and committed abuses of discretion. And I'm glad that Judge McLeese pointed out that in the federal cases, some of them have said the jury discovery could take place without court involvement at all. On the other hand, in this court, the chief gave excellent guidance and gauze to how the court should be involved and assist the discovery effort to sharpen the issues and so on. So there's a lot to be said for court involvement. So if there are no further questions, well,
I do have a question for you. It's kind of a procedural question about what remedy you think would be appropriate for this court to award if we were persuaded by an aspect of your argument. Leave aside the sufficiency argument, which we haven't discussed today, which would have its own implications, but focus solely on this issue. Assume that the court were persuaded by your argument that the trial court did not appropriately exercise its discretion in denying the discovery request. What remedy do you think follows? You use the word remand, but would the conviction remain in place and the case would be remanded for the trial court to give some time for defense counsel to conduct such discovery as defense counsel wanted with the assistance of the trial court if necessary as appropriate, and then to file a motion if one were warranted or represent to the court that no such motion is warranted if none were, and then for the trial court to rule on that motion on the merits if one were filed, and to grant relief in setting aside the conviction if the motion were meritorious, and to deny relief if the motion is not meritorious? Is that what you have in mind, or what do you have in mind about exactly how the remand would operate if there were such a remand?
Everything you said, precisely. That's the way I envision it, Your Honor.
Thank you.
Thank you.
Thank you. We'd like to thank both counsel for your briefs and arguments and the cases submitted.
Thank you, Your Honor. Have a good day.
Thank you. All right, our second case this morning is Catholic Charities, 801 East Men's Shelter versus JAMAR BYRD. All right, counsel, are you ready to proceed?
Yes, John. May I reserve 2 minutes for rebuttal?
I'm sorry, counsel, could you repeat?
May I reserve 2 minutes for rebuttal?
Yes, thank you.
May it please the court? My name is Ian Slingsby. I'm here on behalf of Catholic Charities. Catholic Charities is a proud provider of public services in this district, which includes shelter services for homeless residents. As part of these services, Catholic Charities at times has to undergo emergency terminations. This appeal is about an emergency termination that was arbitrarily and capriciously overruled by the Office of Administrative Hearings. This is for 3 reasons. First, the standard that the judge at the OAH applied focused on a strict review of a single violent action and inappropriately looked at just an action of battery.
Can we stop there? So I just want to make sure I understand what this argument is.
Yeah.
Are you making a legal argument that the ALJ misapplied the law?
Yes, I think that the standard that the ALJ does when reviewing the other AOH cases and how to apply the.
Well, hold on, stop right there. Sorry to interrupt, but we have a statute.
Mhm.
We have OAH cases, I guess, interpreting the statute. Those OAH cases have no binding authority in this court.
Correct.
You know, interesting to see, I suppose, how they've looked at the statute, but can we just talk about how the ALJ applied the statute? Because if this is a legal argument, I think we should be starting with the statute, and it's just not clear to me what your argument is about how the ALJ misunderstood the statutory text
Yeah, so
of the emergency termination provision.
on the statutory text, the ALJ focuses on this concept of a single violent act, which doesn't appear in the statute.
Okay. Where do you think the ALJ focused on this single violent act? Because as I understand it, the ALJ looked at an incident in full context, right? And the full context being, this is a gentleman who has been told unlawfully that he has to leave this shelter
Yep.
previously, right? So, you know, sort of, they keep doing this to him,
Mhm.
I think was sort of the macro context of the ALJ's order. And then the micro context was, and in this instance, the way the security responded to this situation and treated Mr. BYRD was inappropriate. I think that the ALJ described it as, you know, him suffering indignities. And so in that context, the 2 instances of violent acts, potential instances of violent acts, one being a push of a security officer, and 2, the ALJ also looked at sort of the struggling once he had been seized by the security officers, and looked to see if that could have justified the emergency termination, and said neither of those instances, in my view, justified termination in context. That's how I read the ALJ's. So to the extent that you're making this argument of, the court focused in on a single violent act. I just don't see that in the order.
Yeah,
So if we could look at the court's order and the language the court used, or the ALJ, I keep saying the court, but I mean the ALJ, that would be helpful to me. If you want to pinpoint to me what you're talking about and where you think the ALJ misapplied the statutory text, if you're
So-
making a legal argument.
yeah, so there's a lot there. The full context thing, I think, goes toward my second argument, where I don't actually think the full context of everything was presented to the court. But on the statutory review of everything, in the ALJ's order, he focuses on looking at the other two cases. And he talks about the single violent acts that happened in BJ, and he uses it in a footnote.
Well, the court says, I'm persuaded that a single act of violence doesn't necessitate an emergency termination. And so I guess here's one question for you. Do you agree, because it seems to me that you do agree from your briefing, that a single violent act is not per se a basis for emergency termination? Right, you look at the other OAH cases and you seem to agree that those cases were reasonably decided.
That's correct, and I think that
Okay, so
looking
there's
up,
there's no interpretation before us by either of the parties that a single violent act is per se.
I think it's about the comparison that he does between the emergency and the standard termination on the concept of battery, and that being a red herring argument because of the other things that are listed in there.
Explain that to me. I don't understand, because if we're already in a world where a single violent act is not per se a basis for emergency termination, then we're living in a world where a single violent act has to be taken into context, which seems to be envisioned by the statutory language, right? The statutory language says a client presents an imminent threat that you can terminate someone on an emergency basis whenever a client presents an imminent threat to health, safety, or safety of the client or any other person or on a provider's premises, in light of the severity of the acts or acts leading to the imminent threat, right? So it seems to invite a contextual examination. Which
I do
again,
agree.
as you know, my earlier question or soliloquy suggested, I think the ALJ did just such an contextual examination. So again, I'm not understanding what it is that the ALJ did legally wrong, if that's your argument.
I don't agree that he actually did a full contextual that goes to the other part, but I think that that's what's here is like what actually constitutes that level to become a credible act or threat. Or if you look at those other two cases, those were two cases where there were no additional threats or potentials of violence, or in this case, there was additional presentations of violence.
Counsel,
And I think that's where the interpretation is.
Can I ask the question maybe a slightly different way? Could you maybe spell out what conduct you believe posed an imminent threat and what conduct the ALJ failed to include in its analysis?
I think the actual violence that was happening and the continued refusal constitutes a threat. I also think that the video footage shows that even though you cannot hear it, he is verbally making threats, which was corroborated by testimony and by a contemporaneous report, which
So
shows
these are
those.
factual arguments, not so much legal arguments, right? I mean, you're just saying, look, if I'm understanding you correctly, you're saying, no, a single violent act is not per se a basis for termination. You look at it in context, but if it's severe enough, it should result in emergency termination. And this, I guess maybe what your legal argument is this was severe enough given the facts? Is that?
I think so.
Or that the court's bar for severity was too high? Is that your legal?
Yeah, I think his bar based on comparison between the standard and the emergency was incorrect.
Okay, but I guess part of my problem is the facts that you appear to be arguing in your brief are not the facts that the ALJ found. So the ALJ found that it more or less credited Mr. Byrd's account of the encounter. And it largely discredited, or in its words, gave little weight to Ms. Carpenter's account of the incident. It found that she hadn't seen much of the incident. She wasn't there at the beginning when the officers were kind of baiting Mr. Byrd and threw away his food and took away his chair and grabbed at his bag and, you know, did all of these things potentially to elicit a reaction from him. She wasn't there for those. And she just watched a videotape of these things happening. And we have case law that says you don't get to put on a witness to just say that she watched a videotape and testify as to what she saw.
Mhm.
So the ALJ just didn't credit her, lots of her testimony, and did credit Mr. Byrd and watched the 45-second clips of the videos, which came in after the hearing,
Mhm.
and made findings of fact. And it seems like your brief is really kind of arguing against those findings.
I think that is,
Does your argument turn on us holding that the ALJ's findings of fact were not supported by substantial evidence?
I think the second and third arguments are those.
I
yes.
understand that your second argument seems, well, I'm not sure that I can't remember now what your second argument seems to be about past misconduct. I'm asking about your first argument. Did
Yeah.
your first argument saying that the ALJ got the legal analysis wrong, does that turn also on us holding that the ALJ's findings of fact were not supported by substantial evidence? Do we have to agree with you to let you win on that argument?
I don't think so. I think just looking at the severity and if you go based on what the ALJ.
Okay, but stop.
Yeah.
If I look at the ALJ's order
Mhm.
and I look at the ALJ's findings of fact,
Mhm.
and the ALJ tells a narrative of Mr. Byrd going into the cafeteria and not bothering anyone, and security guards coming up to him and taking his food and trying to grab at his possessions and removing his chair and kind of moving him around the cafeteria, and there are 2 officers, and then there's 3, and then there's 4, and then finally there's 8 surrounding him. If that's the narrative that the ALJ gives and we rely on that narrative, can you win this case that this was adequately severe under the statute to justify termination?
I think so, because even if we follow what the ALJ says, I don't think that there was adequate provocation, as he said, that because based on what he says, just that it was not this case where he was just going to the cafeteria by himself. He was breaking the program rules by avoiding security.
Was there testimony that he broke the program rules?
There was, and he admitted to it. And when he said, she's not nothing to me, he avoided her.
I don't think that's an admission of breaking the program rules. I think that's him saying, I don't think I have, I think that's him saying, I'm following the rules. I don't have to talk to her. I'm on side, I can't remember if he said he's on side B and he's on side A or vice versa.
Mhm.
But his understanding was, I'm not required to check in with her.
Okay, but the program rules do require that.
Her testimony, if I recall, was I tried to give him the termination notice, the 15-day termination notice.
Correct.
And he walked by me and I sent security after him.
Yeah.
It wasn't I sent security after him because he didn't check in with me. It was I sent security after him to bring him back up here so that I could give him the termination notice. Do you think that that's authorized? Is that an authorized use of security?
I think so, because the program rooms require tenants to respond to notices of infractions, which would be the infract. They have to
Well, he
accept
might
that.
respond to it, but why does he have to stop at the or why is the
I wonder if
security
I could-
allowed to manhandle him to bring him back up to the
When
desk?
you finish the answer, I wonder if I could jump in with a question as well.
I think that it is a requirement. If somebody is trying to give it to you and under the program rules, it says that you are required to take it, that you have to accept that. You can't just blow them off and forever just avoid staff and in that case, shelter services would never be able to provide service, because I can just say no to you. I will not listen to it. I will not take it.
Just to jump in with a couple of questions, a background question, is Mr. Byrd currently at the 801 East?
He currently has a barring notice from the forget what, another agency. So until May, he is not able to, so that's a different agency.
So he's not there any longer. And then my other procedural question is, you are talking a lot about other acts. I know that's your second
Mhm.
act, and and we were focused on your first argument. Your second argument was about other acts that weren't considered.
Yeah.
Are those other acts properly considered under an emergency termination as opposed to under a regular termination? Seems like you had a stronger argument for a regular termination, if that's the route you wanted to go, where you could bring in all the list of prior violations up until and including this one.
So I think that's one thing that's been inconsistent at OH, what you can actually bring. I do think when it comes to the idea of full context, we're not saying that he should be terminated because of those prior acts, but it gives context to why the officers responded in a certain
Hey,
way.
could you help me, what specifically was proffered to the ALJ about what that other conduct that the ALJ was not interested in hearing about would have been?
It wasn't really, nothing really ended up being proffered because he said that he finds that they're not relevant.
And so it makes it pretty hard for us on review to assess whether that should have been included or not. And so I'm not sure off the top of my head, we have cases about this in the administrative setting, but it's a well-settled principle in the trial court setting that if you're a party who wants to get some evidence in and the trial court says no, if you haven't already, you need to kind of make a record and proffer here, by the way, just so I can make my record, here's what I was trying to get in, here's why it would have been relevant. And I was kind of looking for that and I didn't see
Yeah.
it. And it sounds like there wasn't that. And wouldn't
I
you
don't
think
think he
that would
made a-
be important?
I think you're correct that he didn't make a proffer. There is a difference slightly in this case, which would not typically be on emergency terminations, where the prior termination was admitted into evidence. So there is some evidence of those bad facts, including evidence of the shelter having to call Metropolitan Police to deal with this individual because shelter staff have had trouble in the past handling this individual. So it gives context to this situation.
So would you say that although there may not have been a formal proffer, we could look to the information about the earlier termination as kind of an inference about what it would have been and assess whether that's something that, would have been prejudicial to exclude? Is
Yeah,
that
I
a fair
think so.
process?
I think so.
Can I ask you back on the first issue for a second? It would help as a framework kind of question. I also am trying to make sure I understand your argument about what the nature of the legal error the ALJ may have made was. And in part, I find that tricky because I'm not quite sure which things are questions of law and which things are not. So if you took all of the ALJ's determinations of pure historical fact, this happened, this person said this thing, this person didn't say that thing. And then the question is, the ALJ looks at that and is required by the statute to make a determination. Does this, if those are the historical facts, is this person an imminent threat?
Mhm.
Do you think that's a legal determination? Do you think that we should be reviewing de novo, the kind of attachment of that label to those facts? Do you think that is a factual determination or predominantly factual determination that we should review to see whether there's substantial evidence in the record to support it? Do you think it's something in between that we should review in some different way? What's your view about which aspect, whether that step in the process is purely legal or something different?
I think it's fair to say that there is a little bit of blurriness between that. I do think that if you accept everything of the ALJ as fact, that is what is happening, and you just go based on the fact that there's program rules and the statute.
So I mean, I just want to make sure I catch your answer. So to the extent the ALJ said, here are a bunch of facts, here's my conclusion, this is not an imminent threat.
Mhm.
Do you think that we should review that de novo, kind of ourselves saying, if we took those same historical facts, what would we say? Or should we view that deferentially as like a further primarily factual determination, kind of a predictive factual determination about how threatening someone is?
I think
maybe
it's-
the answer is blurry and that's a
I
fair
think it's
answer,
just
but-
on this, whether or not it's the level of severity, like you could take everything he said as fact, deference to that on that question, that argument, there is deference there. Until you get to the other arguments, if you review those, that there's deference there, I think then it's just de novo on the level of severity under the statute.
That takes me back to your responses to some of Judge Easterly's initial questions about where we are in terms of this legal argument. If we have to defer to the factual findings. Are you saying that they were clearly erroneous
I do
here?
think so, and
And you say that, I'm sorry, you say that this was much more serious than it looked, but you couldn't hear the video.
yeah.
Isn't that part of the factual problem? I mean, are we supposed to assume what was on the video when the witness who said she heard it?
Yeah, so I think.
The ALJ found she wasn't really there for all of it.
So I think that goes to the third argument on the witness there and what her testimony was given, where she used contemporaneous report and everything to back that support up. I also don't think the ALJ properly described the video. For instance, he says that when she entered the facility, Mr. Byrd was under restraint, but the video shows that he was.
Is restraint the
I
word
think
that
he
was
said
used?
under restraint.
Yeah, I thought the word was under control.
Okay, sorry, under control.
And doesn't that then depend on what you think control means? If you think they physically had hands on him, you're right. But if you're, under control in the sense of being contained, like a fire might be contained or whatever, surrounded by people and kind of under their control, then the ALJ's finding might well be supported. So a little bit depends on your inference, I guess, that control meant physically had hands on on Mr. Byrd. Is that fair?
I would say that here, though, it was there's some aspect of what is control here. Here, there's a situation where the video clearly shows that he is freely walking around the facility, and they don't actually try to.
At the moment he walks in, at the moment she walks in, he's freely walking around.
Yes, at the moment Ms. Carpenter walks in, he walks to her and directly engages with her. He, on his accord, goes to her. If you watch the videos, where I don't remember exactly which clips, it's in my brief, I point to. He is the one who engages with Ms. Carpenter first. He walks to her. So how can he be?
Nonetheless, the fact remains that she walks in, on video. I can't even remember what number it is, 8 or something,
Mhm.
right? And it's in videos, 3, 4, 5, 6, where you see all of the baiting. She doesn't see any of that.
So
Um,
I don't think it's proper to discredit her for that testimony with
not
videos.
discredit her,
but
just say she has 0 to add, right? She cannot testify about what she watches in a video. She's not a percipient witness just because she watched it in a video. I can watch it in a video. I'm not a percipient witness.
Yes,
right?
I do think
So
there.
she sees a sliver of what happens at the very end and misses everything that happens with the security guards and Mr. Byrd, where they throw away his food, right? I mean, that seems provocative, at least. They're touching his possessions. They're removing he stands up, they take his chair, they put it on top of the table. This is a way of treating someone that seems to be intended to elicit a result. And they get it, they get a push, and then he backs off and he's walking around again. He's not trying to fight them.
Mhm.
That's not what the video shows, and that's not what the ALJ found. And I think if we're looking at those facts to look at the ALJ's narrative of what happened between the officers and what the dynamic was between the officers and Mr. Byrd, I think it's a hard row for you to hoe to say that the ALJ's factual findings about everything that happens before Ms. Carpenter walks into the room was not supported by substantial evidence.
I do think.
So then Ms. Carpenter walks in the room, and maybe the ALJ gets it wrong as to where exactly Mr. Byrd is with respect to the officers when she walks in the room, but she has so little to add. And if I recall correctly, she's accusing Mr. Byrd of doing things that he clearly doesn't do, throwing chairs. He never throws a chair, right? And she's accusing him of making threats against people to kill. And the ALJ doesn't just rely on the fact that she's just newly arrived in the room. The ALJ says there were all sorts of other witnesses there, and they don't call anyone else to testify about this. And I'm just not going to rely on her single testimony. The ALJ saw her demeanor, right, in person, and decided not to credit her. And that's the kind of thing that we defer to on a regular basis. We're not there. We can't see the witness. So I have a hard time with this argument about, you know, the ALJ not making any sort of error or abusing its discretion in not crediting Ms. Carpenter.
Yeah, so I mean, I don't agree with a lot of how the ALJ characterizes the video. For instance, it wasn't a throne chair. He does flip a chair and place it in between him and the officer. So that was when the officer then put the chair on the
I think
table
there's a
because he's
difference
flipping it
between
there.
an accusation that someone throws a chair, you know, and someone knocking a chair over or using it as a barrier between you and security guards who keep surrounding you.
I don't, at that time, the only security guard that was coming to him was Major Flippin, and they were not trying to
Major
provoke.
Flippin, who the ALJ said was substantially larger than Mr. Byrd and kept kind of pushing him around with his body. And Major Flippin is the one who took his chair. I think it was a different officer who threw his food away.
Yeah, that happened before. But the fact that Major
You
Flippin
say
is,
that as if it were sort of a totally distinct event. You agree that it's part of the sequence of the events. That's
I
sort
do
of
agree, but it's
escalated.
because he's going into the cafeteria, like he's already broken the program rules and they're trying to respond to this.
But that
And this
wasn't,
is,
that wasn't Ms. Carpenter's testimony. Ms. Carpenter's testimony was I sent security down to bring him back up to serve the notice on him.
yes,
Not because he didn't check in with me. And
yes.
that's a
and I
violation of
think,
the rules.
I think that also goes to like looking at the credibility of the witnesses. Mr. Byrd was permitted to discuss more detail, like the past conduct, which is in a imbalance of reviewing the witnesses, which this court has previously said is a reason for turning an ALJ's decision when they look at the evidence of witnesses differently. Mr. Byrd was able to provide that, whereas Ms. Carpenter was prohibited from discussing that. If you get
I'm
that.
not understanding the past conduct, the discrepancy. Sorry.
So he was able to talk about like why he thinks that why they were provoking him and everything, but the facility isn't able to talk about why they had to send so many officers. If you see the video, originally they do just try with the couple.
Well, the fact of the matter is the facility had on a number of times terminated his services unlawfully,
But
right?
it's
And
just,
the ALJ knew it because the ALJ had presided over those cases and took judicial notice of that fact.
so the current, what was happening there was it was a procedural error. He hadn't been served properly. So that's what this case was doing. They were trying to rectify a procedural error and give service.
Well, one could
properly.
argue that they were trying to, again, evade the procedure of giving him 15-day notice by ginning up an emergency situation to justify the termination immediately.
Catholic Charities is an organization that purpose is to keep people off the streets. They are not trying to push people out. They only do this for the safety and security of their people. They're not trying to gin up the situation to cause violence.
Can I ask you a question, Counsel? You made a comment earlier. I believe you said it was a red herring argument that appellees made, trying to differentiate between the type of battery that's needed for a regular termination versus the type of battery that's needed for an emergency termination. Can you elaborate on that argument, please?
Yeah, I just think it's a red herring because if you look at the standard termination, which that's from that whole line of reasoning, oh, it's a battery, you can also do a standard termination, everything it should have been there. That goes for literally everything. I mean, the act at subsection, that same standard termination at subsection E says intentionally and maliciously vandalizes, destroys property. But if I was trying to set fire to the building, that is an imminent threat to health, would be emergency termination. Subsection D then says endangers the client's own safety or the safety of others on the provider's premises. That goes to pretty much everything that would be an emergency termination. So like focusing on that, I think is a red herring argument because in that case, the standard termination is proper for every emergency termination, which would make sense, but that focusing on that rather than the severity of the case.
So I guess that goes back to my earlier question about, it seems like there may have been a stronger case here for a regular or another attempt at a regular termination here as opposed to an emergency termination.
I don't think so whenever he's making threats to kill people by the end of the week, which
That
was
the
put into
ALJ
report
did-
contemporary.
Did not credit. So we have to overturn the ALJ's determination not to credit Ms. Carpenter on that point for us to rely on that as a basis to say that the ALJ erred in not finding an emergency situation here, correct?
If you're only going on that correct. If you're going based on just the video, I think the video is enough, because if you compare it to other cases like BJ or NP, where there is no other violent acts happening. This is a mother trying to pick up her child and throws up her arm. This is a playful
Those
punch.
cases are, dots on a map, but they're not binding on us.
I know that-
We're trying to figure out how to interpret the statute, and you're saying that the ALJ made a legal error in assessing severity here.
Yeah, because I think that just going on just the video and what the ALJ said.
So you're saying your argument is per se, looking at Mr. Byrd's actions in the video, that was per se severe enough such that the ALJ had no choice other than to say emergency termination was warranted.
I think so, yes, on the
Okay,
video.
that's helpful. Thank you.
All right, any other arguments that you want, and I know our questions took you a little longer than your time, but we'll reserve your time for rebuttal.
Thank you.
Good morning, Madam Chief Judge, Your Honors, and may it please the court. Laura Nide on behalf of respondent, Mr. JAMAR BYRD. We are here today because petitioner wrongfully terminated Mr. BYRD from its shelter under the emergency termination provision of the DC Homeless Services Reform Act. The Office of Administrative Hearings came to this conclusion by applying the proper statutory standard and making findings of facts supported by substantial evidence. Mr. BYRD asks this court to uphold Judge Campbell's final order for 3 reasons. First, OAH used the proper standard of emergency terminations. Second, 801 East fails to show that the statutory standard was applied arbitrarily, capriciously, or contrary to law in this case. And third, OAH's evidentiary and credibility determinations were not arbitrary and capricious and afforded great deference. However, before I turn to my 3 points, I would like to make several clarifications. First, in response to Chief Judge's question about whether Mr. BYRD is currently in the shelter, respondent understands that the DHS barring notice was expired in March of 2025, not in May. And that's at the appendix, I believe, 137. And then as to Judge McLeese's question as to where our standard, what is the question of law and what is the question of fact? As respondent understands it, the question of law here is what is the standard that should be applied? Everything else is a question of fact to be determined, to be given great deference to the ALJ's determinations. And the standard in this case was properly applied. So to turn to my first point, OAH used the proper standard for emergency terminations. And that standard is that the providers must prove that the resident is an imminent threat whose acts were so severe that they warrant emergency termination and immediate removal from shelter. Now, imminent threat is insufficient on its own to justify emergency termination. The emergency provision statute specifically includes a severity analysis. If imminent threat always justified emergency termination, the severity analysis would not be included in the emergency termination provision. Now, while OAH jurisprudence is not binding on this court, it is persuasive to look at OAH past jurisprudence addressing.
Can I ask you, you talked about the severity component, and the language of the statute is in light of the severity of the act or acts leading to the imminent threat. So does that include, in this instance, all of Mr. BYRD's prior alleged activity leading up to this point? Because I guess I'm understanding implicitly, maybe incorrectly, appellant's argument that Mr. BYRD had a history here and that it was starting to escalate up to this event, which they view as the most severe. The problem is that's not reflected in the findings that the ALJ made, and should it have been? How long is this timeline when you're looking at the severity of the act and the imminent danger?
Your Honor, no, the past alleged act should not have been included in this case. And respondent does not want to proffer an arbitrary line as to when when acts are relevant versus when they're irrelevant, and that discretion is up to the ALJ. And in this case, there was only one piece of evidence that was explicitly excluded, and that was this October notice. There was no proffer for direct testimony from the alleged October incident. There was also no proffer related to the March 14th incident, so no direct testimony was excluded there either.
I get those procedural points, but if imagine that those procedural problems didn't exist, and imagine that it had been clearly argued to the ALJ. Here's what we're faced with a video, and we think that is a severe act. It depicts severe acts that justify immediate termination. But understanding that, being persuaded by that, requires taking into account things that happened before. And some of the things that happened before are the situations that were analogous to this escalated previously in ways that meant that the MPD had to be called or whatever. Would you think that an ALJ could permissibly say, that's just irrelevant to me. I am not going to broaden the temporal focus beyond the scope of the video? I mean, would that have been a correct relevance ruling if the procedural problems you're identifying didn't exist?
I think it could be, but it also depends on what the provider relied upon in coming to their emergency termination. The notice and incident report related to
I
the.
get that. So I get that's another procedural point. You think that if I'm sorry to interrupt, but is the thrust of that point that if the notice says in this conduct depicted on a video, you engaged in severe conduct that gives rise to an imminent threat. And then at hearing, somebody wants to say, that's our theory, but in evidence in support of that theory is, if we want to show that that really was an imminent threat, we can show that similar things happened, 3 weeks earlier, 7 weeks earlier, that ended up spinning out of control. That's going to prove that the acts that are depicted in the video are, actually did rise to the level of imminent threat. Are you saying that that evidence would have to have been somehow included in the notice originally, so that there would be kind of notice of what evidence was going to be used to support the claim that the depicted conduct and the severe act was an imminent threat? Is that your line of thinking?
Yes, it should have been included.
And what's your support? I mean, why would you think that's true?
Yeah, the statute in the emergency termination provision includes an obligation for providers to alert the Department of Human Services of the act or acts leading to the emergency termination. And they provided the same incident report that was attached to the notice that was provided to Mr. Byrd.
But why is that in the hypothetical where, I mean, it doesn't say you have to provide not only notice of the acts that constitute the severe acts that give rise to the imminent threat, but you also have to give notice of any other acts that you are going to rely on as establishing or supporting your assertion that those acts constitute an imminent threat. That's not, that didn't seem to be in the language you were quoting. There didn't seem to be a requirement not only to give notice of the acts that constitute the severe acts, but also any evidence you're going to rely on about other circumstances that support a conclusion that those acts constituted an imminent threat.
I believe it is a reasonable interpretation of the statutes because it says act or acts leading to the imminent threat. That is all encapsulative. That doesn't just include the acts that were specifically the grounds, the specific incident. If they were going to rely on this, they should have included it, and they did not do so.
Is it just a question of notice, or is it also just kind of an understanding of why the agency did what they did, right? Like, aren't they supposed to explain in the emergency termination notice, this is why we think that you pose an imminent threat? It's because of what you did on March 22nd, which is an escalation of the behavior, that we have been seeing over the past 6 months or whatever, right? Like, doesn't that have to be actually part of their decision making? It seems sort of after the fact, if they're bringing it up at the hearing and not part of their actual decision to terminate him on an emergency basis.
Absolutely, Your Honor. It should have been included because as it is part of the acts or acts upon which the provider is relying for the purpose of emergency termination. Now, in this specific case, the October 2023 notice, which was the only excluded piece of evidence proffered, that was also overturned by OAH by petitioner's failure to prosecute. So not only were they attempting to get into this, into the record, this evidence of this termination notice, standard termination notice, but OAH had previously overturned that because petitioner failed to prosecute on Mr. Byrd's appeal.
That's not the one where the service wasn't completed, the October one.
The service was, that was not completed was the March 14th incident. And the March 14th standard termination notice was entered into the record.
Can I ask you about the notice point you're making, and I guess the related question of what the actual grounds were for the termination decision by the agency? Were those the reasons that the ALJ, either of those two issues, the reasons that the ALJ declined to permit the petitioner here to introduce this evidence, or was the stated reason for the ALJ only relevance?
I believe the stated reason was only relevance, but tied to the relevance is the fact that this was an emergency termination. An emergency implies immediate. What was the immediate acts that led to this? And
Right, but again, back on just purely relevance, if, the immediate act is, what's on the videotape, leaving aside these procedural questions about notice or about what the actual grounds were for an agency, for the shelter's decision, separate question what the actual grounds were of the ALJ's decision. As a matter of pure relevance, just that it's an emergency termination based on a particular act at a particular time doesn't really, I think, say too much about what the time frame is that one could look for relevant evidence to try to understand the gravity or the threatening nature of a particular act that is a basis for an emergency action. Are you saying that the idea of emergency somehow affects the temporal scope of what would be logically relevant?
I believe that the term emergency necessitates considering that temporal scope. However, because Judge Campbell was also the judge that presided over the October 2023 appeal that petitioner failed to prosecute, he already had the requisite knowledge that it was irrelevant because he had overturned the October 2023 notice.
And what do you make of your opponent's argument that applying a strict temporal sense of what was relevant was asymmetrical here, because it's a big part of the ALJ's thinking that understanding this incident requires understanding the prior unlawful acts of the petitioner in terminating your client. That does seem to be outside an immediate temporal focus. So what's your argument about a response to the idea that there's a sort of a asymmetry in the ALJ's approach to what the relevant time frame was in considering the context of the situation?
Well, it all comes down to discretion from the ALJ. The ALJ is the one in the room who is looking at the testimony. It gets to assess whether or not the proffered evidence is relevant to the case and incident at bar.
That's fair enough in the abstract, but what's your concrete answer about why it would be sensible here to say, leaving aside procedural questions, but if the issue was the ALJ is trying to make a determination here about imminent threat and severity. And if the ALJ says, well, figuring that out, I'm going to consider that this was that Mr. Byrd was responding to, and this is part of a course of conduct where the shelter had been unlawfully terminating him from its services. But the shelter is saying you should also take into account that there have been prior incidents, not in a widely discordant time frame, but in the same general time frame, there have been similar incidents where there were issues that arose that required calling MPD and the like. Why would an ALJ appropriately exercise this discretion, which it concededly has in making relevance determinations, in saying the answer is yes to the illegal conduct of the shelter context and no to the evidence suggesting there had been prior altercations that required calling the police? What would the logical basis for an exercise of discretion drawing that line be?
I think the logical conclusion there is to understand why Mr. Byrd may have reacted to the officer's confrontations the way that he did. But also, the
But
purpose.
I mean, again, apologies for interrupting, but the corresponding point by your opponent would be the prior altercations help explain why the shelter responded as it did. And also might color how a reasonable person would assess whether Mr. Byrd was reacting appropriately to the way the shelter responded as it.
Well, if the petitioner wants to rely on that, they should have proffered that in the record.
I get that procedure. I 100% get that procedural point, but I'm still hung up on your relevance point that I'm struggling more with.
I think that in the abstract, there are instances where prior conduct could be considered. I mean, it depends on the context of the conduct, whether or not the provider adequately prosecuted, if there was an appeal and other considerations like that. But in this specific case, Judge Campbell had the requisite knowledge that they failed to prosecute multiple standard terminations after Mr. Byrd appealed, and therefore ruled that they were irrelevant because as they stood if petitioner was so worried about these past incidents, why did they fail to prosecute it when Mr. Byrd appealed? And that's the whole reason that Mr. Byrd was allowed back in the shelter on March 22nd. He had got a ruling from OAH via email, and 801 East's own staff told him via email that he was allowed back at the shelter because of a failure to prosecute a standard termination. And in this case, because of their failure, if petitioner has all of these concerns, why weren't they prosecuting this on appeal? It wasn't until the emergency termination appeal that they decided to actually stand up in front of
Well,
OAH.
can that be used against him? The fact that he didn't, that the agency, I don't see that as a basis to use against the agency, that they failed to prosecute prior standard appeals. I hear you seeming to suggest that that was a factor that the ALJ could weigh in determining whether there was a valid basis for the emergency appeal. I mean,
Your
there could
Honor-
be a lot of reasons that they didn't prosecute all of them. They prosecuted the March one and ultimately didn't obtain service. And I think, as I understand it, that was mooted out, but
Your Honor, in regards to that, that only goes to whether those notices would be relevant to the emergency termination in this case. It doesn't necessarily just indicate that petitioners' other arguments or other reliances related to this incident.
So
are-
can I just make sure I understand? So you're saying, for example, there's an October 2022,
Three.
2023, because this is March 2024. Okay.
Mhm.
There's an October 2023 notice for just regular termination that they serve him with. And then he says, wait, I want a hearing on that. And then they fail. I think it's not that they don't show up, but the court says, well, I've got a lot of questions. And they just don't answer the court's questions. They don't file the report, right? And then the court says, look, if you're not going to answer my questions, then I'm gonna dismiss this termination notice, right?
Yes.
So your point is, look, they could have defended that termination notice. They didn't answer the court's questions. The court terminated it. So then how can they then go back and rely on this as something that showed the pattern? They have to actually litigate these cases, if Mr. Byrd is going to challenge them. That's your point.
Yes, Your Honor. And it's
Okay.
important to note that the burden is on the provider to show that the emergency termination was proper when it's on appeal. And the provider here failed to do that.
Can I
multiple
ask
times.
one other record related question? So this comes up, I think, on page, is it 41 of the transcript? Where they're trying to ask Ms. Carpenter, I could have the page completely wrong. Let's find out. Yeah, no, I think that's totally wrong. There's a point where they're trying to ask Ms. Carpenter about prior rule violations, correct?
Yes.
Do you know where that is in the transcript? If you can beat me to it.
I believe
You
it's,
were the
if you're
prize.
looking At the appendix site, it's 38 and 39.
38. and
Um,
39.
And
Okay.
there's also more, I think, on 37 as well.
Okay. And so they're asking about prior rule violations. And the court says, I don't really want to get into program rules because this is going to come down to emergency termination. And they say, okay. So there's no kind of back and forth where they're like, well, wait a second, the program rule violations are actually going to be relevant to the emergency termination at that juncture. They don't really explain that to the ALJ.
Correct, they do not. There's no
Okay.
objection, there's no proffer on anything other than if you go up
This-
page 38 of the appendix, apologies, Your Honor.
No, go ahead.
The petitioner counsel states at line 6, to demonstrate that he has a history of noncompliance with the program rules. That's the only proffer of relevance for that. And there's no other objection or proffer made related to any of the previous alleged incidents.
Okay, and then in their brief to this court, though, they bring up prior incidents. And in fact, they seem to be pointing to documents in the appendix. And I'm just kind of curious whether those documents are actually in our record. I think they are. So I think that there's some sort of discussion from the October incident about destruction of property. Is that right?
From petitioner's brief?
Yes.
I believe so. They do reference that, yes.
Okay, but there is a document in the record. I mean, did it come into the record or is it fairly within the record because the ALJ said I'm taking judicial notice of these other? I guess I'm just wondering, like, at one point they're trying to ask Ms. Carpenter about rule violations. But in fact, if the ALJ took judicial notice of all the records from these prior cases, then this information was before the ALJ.
The only specific notice that I believe was explicitly excluded from the record was the October notice. But it is still discussed in Judge Campbell's findings of fact.
So is it improperly in our appendix or because we have something in the appendix that references this incident?
I believe that it's in the appendix because petitioners offered it, not that it was actually included in the record.
Okay. And I mean, do you have an argument as to why an accusation of destruction of property might not be super helpful in showing an imminent threat to individual persons?
The argument is that the imminent threat standard is set forth in statute, and an imminent threat is not created by destruction of property. It's showing there's an act or act that threatens the safety of either the resident themselves or the provider, anyone else in the provider's shelter. And destruction of property, even allegedly, because that was overturned by OAH, does not imply any sort of threat to safety of any individual.
Okay, and then the other incidents are the March 14th incident. I think where there's a reference to Mr. Byrd getting quote unquote physical. Is there any indication in these record materials that, because physical is sort of vague, that Catholic Charities was in a position at this hearing to present any more information about the nature of these alleged incidents? I mean, I don't think Ms. Carpenter was the author of these reports. Is that correct?
That is correct. She did not author any of the reports except for the emergency termination notice incident report that we are here today. And as far as I am aware, petitioner offered no proffer of direct testimony related to either of the events. And there is no proffer that Ms. Carpenter even had any direct knowledge related to these events.
So had the court said, fine, you can, had this line of questioning about prior rule violations not been shut down by the court, are you saying that there would have been another reason to object to her testimony because it would have just been hearsay and she had no personal knowledge of it?
Yes, Your Honor. And in fact, even her testimony related to the March 22nd incident is largely hearsay, as Your Honor pointed out during my friend on the other side's argument that Ms. Carpenter witnessed most of the incident via video, or at least reviewed the video because she was not present. And she spent most of her testimony, as found by Judge Campbell, reading directly from the incident report. The language of her testimony directly lines up with the language from the incident report. She did not independently corroborate anything from the incident report. And so all of her testimony is, I mean, Judge Campbell justifiably mistrusted a lot of her testimony because of the clear indicia of unreliability. Your Honors, if you have no further questions, I thank you all for your time and we ask that you affirm. Thank you.
Right, thank you. All right, Mrs. Slingley? Slingsby, excuse me.
Slingsby, yeah, no worries. So just to point out the October,
Just a factual question before you get to the
Yeah.
October matter. What evidence, remind me the evidence that Catholic Charities put on about the threats? Was it just showing the video without the sound? Or was that part of the testimony that Ms. Carpenter read from her notes?
it was testimony by Ms. Carpenter, the contemporaneous report that was admitted into evidence, and the video.
Testimony that she heard the threats or?
Yeah, so that's there in the video, it shows the threats coming directly at her. He walks up to her and he is part of that. It's important to note that
That's where we can't hear.
you can't hear, but you can see him directly facing her, yelling at her.
And is her testimony that his words were the threats or that his physical actions were the?
I think it's both, because there's also physical actions, like she gets headbutted in the back during the incident. So she also had physical actions against her. And it's important to note that the security don't actually try to physically restrain him until he's making those threats to staff. Not even like, they were trying to be more cordial when it was just security on him. So
And so they were, who's
You
the other
think throwing his
person?
food away and taking his chair out from underneath him was trying to be more cordial? Is
I
that
don't
how
think
you're
they-
gonna describe those events on the video?
I don't think they took his chair from underneath him. It was after he put it in front of them, that's when he moved the chair. I think an officer trying to respond to security officers in these shelters, which are
I
tense
just think,
situations.
you lose some credibility when you try to use adjectives that maybe don't align with events that everyone can see and that the ALJ saw and found as fact. So,
I would say that, yeah, I hear you with the food, the chair thing. I think them moving the chair after he placed it in front of him is fair. I think that was fine. The food thing, I hear what you're saying. I take that, but I think it was because they were trying to respond to somebody who was breaking the program rules, and I think security should be able to respond to that.
You were gonna. make
Yeah,
another
so just on my points, the October 2023 was in the record as part of the procedural background of this case. It was the appendix that was provided. The only thing that was added to that appendix were the other cases that the judge cited the NP and BJ cases. Everything else was the record from OAH as part of the procedural background, including the attachment
And
to
was
it.
admitted into evidence.
And was admitted
in that
there.
proceeding.
Yeah. So the thing is though, that the judge felt that while he will give relevance of that to Mr. BYRD, he will not do that for Catholic Charities. This court has previously held that witnesses must be given the same context.
so
And
it was all admitted, but I don't see where Catholic Charities made the argument. Please, Judge, you've admitted, you've taken judicial notice of all of these records. Please consider all of the other incidents of him being violent or destructive and let us tell you what those are, right? The only exchange in the record is Catholic Charities saying we'd like to question Ms. Carpenter about rule violations. And that's just a far cry from making a request to the ALJ to consider what what Catholic Charities now is sort of suggesting is this mountain of evidence of prior bad acts.
I don't think that's true, because then when Mr. Byrd was testifying, he started testifying about his history. And at that point, we brought the point up that we weren't allowed to testify. He shouldn't be able to. And that's when the judge said, whatever Catholic Charities has to say about it is irrelevant, because it's only about the media. What he thought was like.
Are you referring to appendix 115 to 116?
I
Is that
think
what you're
so,
talking
yeah.
about? That was during Mr. Bird's testimony?
I believe, yeah. He was trying to tell about like why he felt he was properly treated. The judge felt like it's okay to give him that, but it is not okay to give Catholic Charities the reasoning, such as the October report, which was in record and was tried to be
Right,
asked
but
about.
Catholic Charities says, I object, you're not allowing me to introduce his prior malfeasance, seemingly referring back to rule violations, which again, like Catholic Charities hasn't really explained to the judge, we want to show this, mountain of evidence of escalating bad, violent behavior. I mean, rule violations could be, he didn't check in at the desk, he's not working, he is,
I think that by
he's not making his bed, I don't know, but, and so then he says, I think the difference here is that Catholic Charities is alleging that the conduct specifically was the base, and it's looking at the termination notice is alleging that the conduct specifically on March 22nd in itself was the basis for an emergency termination.
yeah.
It seems like a fair reading of what the termination notice says, which also doesn't reference an escalating sequence of behaviors by Mr. Byrd.
I don't think that that's true. The record does show that we're trying to give him termination papers and he refused the notice of termination. This is on appendix 192. So he was trying to give the appendix records. USP Officer Woodward called for backup. This is in the notice. This is explained to saying, so all she is doing and explaining, why did he have to call for backup? Because this is somebody who we've had to call Metropolitan Police for before. This isn't something where we can respond to with just one security officer or something. We've had to call the police to deal with it. Now, while we didn't go in to start arguing with the judge, we did object and we didn't go on further because he said it's irrelevant. So if there are no other questions, I ask you to overrule the ALJ's decision.
All right, thank you. I'd like to thank both counsel for your briefs and arguments. And am I correct in understanding that some counsel are before the court on a pro bono basis? So I wish to thank you all for your time and effort you put into your briefs and your arguments today. Thank you. And we'll take that matter under advisement.
All rise.